It's a clear notice requirement.
Right, but how that applies is a little tricky, and I think in the case...
Why? I mean, your argument is that in 1974 and 1960, sex meant biology, and that it's not clearly, there's not clear notice otherwise. Why isn't that the end of it?
Again, so I think the end of it is the statute clearly doesn't permit this claim. I'm just saying that I would be cautious about speaking about how the clear notice requirement applies, because it is not a clear statement requirement.
I understand that. You're not answering my question with
how
respect.
so I guess what
if it's a clear notice requirement, at minimum, and a voluntary agreement, and sex at the time of the statute meant, as Bostock said, you know, there's a good argument it's biology. And why wouldn't West Virginia be within its rights to say we didn't have clear notice otherwise?
The scope of the clear notice requirement is a tricky question. If you look at this court's cases, I suspect...
What's tricky about that?
I suspect Your Honor would think a lot of the cases where this court has found Title IX to apply, you would think there's not clear notice.
All right.
And so I think it's a tricky issue, and I think it's a case that should be briefed, and I don't think it's an issue you need to solve in this case.
And then on the statute itself, it speaks of discrimination in program or activity, and in Davis we explained that that requires kind of a look at the whole of the institution, because the definition of program activity is the whole institution. And so that's less individual focused, it seems to me. Thoughts?
Well, I think that's true for the funding, but I don't think that's true in terms of how the discrimination provision works. If you discriminate or exclude in one part of the school, I don't think you could justify that by saying, well, all the rest of the school, we treat everyone fairly. I think those cases you're talking about, as long as you're receiving funding somewhere, the whole school's activities are covered.
Okay. And so it really boils down to the living accommodations provision, which Congress anticipated there would be sex-separated living accommodations being permissible, the Javits Amendment, and then the regulations that are long-standing and then therefore are entitled to some serious consideration.
Well, no. So, you know, Your Honor asked why we run the similarly situated argument. Take, for example...
No, don't bring that back up.
Well, locker rooms and showers aren't covered by any of the things you just identified. Not the living facilities provision, not the Javits Amendment. None of those things covered locker rooms and showers. So unless you use a similarly situated requirement, you would have to say that Title IX bans single-sex locker rooms and showers.
Okay, all right. If that's your view, then let's talk about the similarly situated. I guess I have to. What about the hypothetical I posed earlier that when it comes to high school performance, girls are sure a lot better than boys, and so we're only going to have remedial classes for boys and girls aren't free to attend?
So I don't think those differences are based on inherent biological differences.
Well, let's say I've got really good science. I mean, it's all about the science, right? I got the science. You're fighting the hypothetical.
I'm not fighting the hypothetical, Your Honor. I think what I would say, Your Honor, is that this court has held in cases like VMI that in general, classification based on sex is impermissible because in general, men and women are similarly situated. Where that's not true is for the sorts of real, enduring, obvious differences that this court talked about in cases like VMI, the differences in reproductive biology. I don't think the sort of pseudoscience you're suggesting has been baked into the
it's
statute.
not pseudo, it's good science.
That's pseudoscience to say boys' brain development happens at a different stage than girls' does.
Well, with all respect, I don't think there's any science anywhere that has suggested that these sort of intellectual differences are traceable to biological differences, and I don't think the statute
with
should be read
respect,
to
I don't
cover
think you're a PhD in this stuff, and neither, I know I'm not, but I'm asking to deal with a hypothetical.
And so I guess what I would say about that, Your Honor, is...
I mean, the statute says no discrimination on the basis of sex. Right. And you're saying, it's okay when they're not similarly situated. And I'm giving you, you're worried about locker rooms, right. Great, I appreciate that. But I'm worried about that math remedial class or the chess club or whatever.
Right, and so look, let me put it this way. The general rule is you have to treat men and women the same. And
I would have thought that's what the statute says.
And I think you have to be very careful about recognizing an exception. And so when you recognize an exception for what's similarly situated, I think you should tether it to the sorts of long recognized differences that would have been recognized at the time the statute was enacted. At the time the statute was enacted, no one would have doubted that it said it didn't require
I think at the time the statute was enacted, 1964, there are a lot of people who thought boys are better at certain things than girls at others that we don't believe anymore.
Not based on inherent biological differences.
I think that maybe in 1964 they did.
And if they did, they didn't have any basis for it. Whereas for
And I'm giving you a hypothetical where I have the science to prove it, and you're saying it's still not good enough.
I guess if you're asking me a hypothetical where the science existed in 1972 and everyone agreed with it, then it might be a different inquiry. That really is a hypothetical because
Mr.
there